Good morning, counsel. Trust you had a good weekend.
Good morning, Your Honor.
Well, good. Mr. Boutros, I understand you have some matters that you wish to present before closing with the plaintiff's case.
Yes, Your Honor. Two things before we proceed to Mr. Dusseault's evidentiary presentation. The first relates to the proponent's announcement over the weekend that they were planning to call Frank Schubert as a witness. And we filed a motion to exclude Mr. Schubert's testimony on several grounds. And because of the eminence of all of this, we are hoping we could take that up first thing today. As the court may recall,
Should we take this up before the plaintiffs have presented their case?
Well, one reason I was hoping we could take it up sooner rather than later is that to the extent the proponents are going to put Mr. Schubert on the stand to talk about the genesis of the strategy and the campaign strategy, we think that would, well, number one, be a waiver of these privilege claims that were invoked over at least 76 times in Mr. Schubert's deposition, and which formed the basis of the withholding of thousands of documents. And we think it would be inappropriate for the proponents to have it both ways. On the one hand, blocking any inquiry. If the court were to review the deposition of Mr. Schubert, it is remarkable the obstruction in terms of our inquiry. 76 objections, instructions not to answer. If one looks at page 58 through 65 of the deposition, it sort of encapsulates the degree to which our inquiry was blocked. And in terms of the authentication and admission of documents, which was the ostensible purpose that Mr. Cooper suggested on Friday for Mr. Schubert's testimony, we have let the other side know we have no objections on authenticity grounds. And in fact, we're not objecting to the documents they at least first identified as exhibits. So either there is no reason for him to testify, or to the extent he does, they are opening up a whole new world which we would be entitled to get documents from him so we could conduct the examination of him.
When did you learn Mr. Schubert might be called as a witness? If I remember our proceedings on Friday, Mr. Cooper stated there would be two witnesses presented by the defendants, both expert witnesses, Blankenhorn
and Miller.
Blankenhorn and Miller. Schubert was not mentioned. So when did you learn that the defendants might be calling Schubert?
We first learned Sunday morning at about 8:30, I believe, in the morning, that Mr. Schubert would be their witness. And well, as the court will recall, Mr. Cooper did say on Friday that there might be one other witness, and the primary purpose of that witness would be to authenticate documents. So frankly,
I see.
Yes, and so we learned Sunday. We filed our motion last night. We did ask them. We let the proponents know that we were not going to object to the documents on authenticity grounds. They are mostly campaign documents and the like. So we're hoping that would resolve it, because you know, we had a lot of questions for Mr. Schubert and weren't allowed to ask during his deposition. And they have zealously protected any meaningful inquiry into anything regarding his thinking, his state of mind, his strategic vision. They wouldn't even let him answer questions about the article that he wrote and published, in many respects, during his deposition. So that's why we would like to get that resolved, because if he is going to testify, there are a number of things we would have to do, and probably be ready to cross-examine him tomorrow.
Who is going to field this on the defendant's side? Mr. Thompson or?
Miss Moss will, with the court's permission.
Ms. Moss, good morning.
Good morning, Your Honor. First of all, we received their motion at about 11:30 last night, and so to the extent that the court would like a written response, we'd like 24 hours to have until tomorrow. But I think that the bigger point would be this may be moot. We don't know for sure that we're going to call them. It depends upon, at the close of their case, what evidence comes in. I mean, there's a variety of documents that we have not been able to agree on the admissibility of, and depending on whether those come in and what sort of tender the plaintiffs make as to their relevance and significance, we may need to have a witness such as Mr. Schubert testify to those documents. And specifically, those documents were the ones that were ordered to be turned over following the Ninth Circuit's revision of its opinion regarding the First Amendment. I mean, they had been withheld, and my understanding was the court's order was, if they wanted, rather than reopening the deposition of Mr. Schubert or any of the other witnesses, that they were free to have called them and to have asked them questions on the stand. And in lieu of that, they're wanting to move into evidence a variety of documents. And any questioning that they would have of Mr. Schubert would be limited to those documents. If we feel it is necessary to do so following whatever comes into evidence. So yeah, it's not clear that we're going to need to call them for anything more than authenticating documents. And that may itself may not have to happen if they are in fact going to agree to the exhibits we want to move in are admissible.
Have you been informed which documents the plaintiffs intend to introduce?
Yes.
Well, would that not tell you whether or not you need Mr. Schubert?
Well, it depends upon if they actually come in. I mean, what significance the plaintiffs are placing on these documents. I mean, this may be jumping ahead a bit, but one of the
assuming that they all come in.
Okay.
Isn't that an assumption that you have to make?
Yes, Your Honor. But if, it depends upon if they come in. Just come in blank, or if they come in with, as we contend, some kind of a tender by the plaintiff as to why each of these documents that is not coming in under a sponsoring witness is, I mean, what its significance is and what its specific relevance is to the case. I mean, they're moving in documents.
The evidence is what it is.
Well, they're going to be presumably making representations about what these documents are, and we would contend that the appropriate time to know what those representations are is now. I mean, what significance are they placing on some of these documents so that we can determine, I mean, do we need to have a witness respond to them as opposed to having to wait until their post-trial briefing when, for the first time, we learn that they're contending a certain document was authored by the campaign when we know that it wasn't, or if they're contending that a document shows something that we know it does not. I mean, we would have no way of knowing that. And if they have not questioned a witness about that or made some sort of a representation about what the specific relevance is of some of those documents.
These are defendants' documents, are they not?
Some of them are, and some of them are not.
How many documents are we talking about?
I'm not sure.
Mr. Dusseault.
Your Honor, we've reached agreement on a number of them. I would estimate the ones that we haven't, and I've tried to put them into groups. It's probably 30 to 40 in total, and I'm going to try to address them in groups so that we don't have to do them one by one.
What is the source of these documents, or the sources of these documents?
Your Honor, I think we can fairly well put them into groups of three, or a group of three. The documents that were produced before deposition, some of which foundation had been laid, documents that were produced during the trial, but from them and from their files, and then a couple of documents that are from websites, where we've shown them the website that we got them from. For example, we go on a website and see that there's a simulcast that says presented by protectmarriage.com. So we've shown them that. And that's, I think, generally the three sources. From them during discovery, from them during trial, and then from the internet.
Well, are you saying that you believe the source of all 30 or 40 documents, whatever the number is protectmarriage.com?
Well, there are a couple of documents, Your Honor, where the source itself is not protectmarriage.com, but we do have evidence that shows, for example, that protectmarriage.com was involved, funded it, reviewed the drafts, And there's a connection that in the course of my presentation we will show. Now that's a minority of them. But there are a couple where we are showing a connection of a document that comes from another source, but they screened it in advance.
And I gather that category of documents is the category you're concerned about, Ms. Moss, is that correct?
That is correct. I mean, you know, that is correct. I mean, for many of these documents, we don't dispute that they were produced from files of the proponents for protectmarriage.com, but they are not. They may, for instance, have been something that was sent in. And whether it was in fact reviewed, whether it was authored by, paid for by protectmarriage.com is very much in dispute. And whether or not we need to put on evidence about that, I think, would depend upon what tender plaintiffs are making as to what presentation that document, I mean, what they're claiming that document represents. And normally, if it were coming in through a sponsoring witness, they would have to ask those questions. I mean, it would be clear through the testimony of the witness, and we would have an opportunity to then, on cross of that witness, to clarify anything that we felt needed to be clarified. I mean, if the documents are just moved into the record, then we may well need to put on a witness, such as Mr. Schubert, to testify about these documents, to clear up any issues to present any facts that we believe need to be fairly presented. And these documents that, you know, these are documents that they're moving in. So to say that they need additional documents beyond that, I don't think that we've waived anything. I mean, these are documents that we produced because we were ordered to do so, and they are moving them into evidence. And so I think it's perfectly appropriate for us to be able to question the witness about them, about those specific documents, without necessarily going beyond that into the two other areas.
Your Honor, if I could make one clarifying comment. We're hearing this argument for the first time. They disclosed it yesterday, and I think it was at 8:29 documents they were intending to use.
AM or PM?
AM, with an 8:30 deadline. And I believe, I mean, as far as I can tell now, there's only one document in the group that we've asked them to agree to that's on the Schubert list. There are many, many documents on the Schubert list. And as far as we can tell, only one of them is a document that we've asked them to agree to. So clearly, they are trying to do things with Mr. Schubert that go beyond the documents that we are trying to move into today.
Your Honor, the documents that we identified were they were documents that we were wanting to move into evidence, not the ones that they have themselves identified. We were identifying new exhibits that we would intend to put in through him, which are the public ads and statements from the campaign, which I understand them by their response to my email to say that they had no objection to. I mean, if that was all that it was, we wouldn't need to put him on the stand. But we don't know that. As of this point, is what additional documents are going to have to come into the record. And if everything that they have identified is going to come in, then we would like to have the opportunity to determine whether we, in fact, need to put him on the stand and ask him about those documents.
Could I add one point, Your Honor?
Last point.
This is it. This will be my last point. On this question of the proponents wanting to question Mr. Schubert about the documents, we asked him in his deposition over and over about documents, including on page 2 of the motion. We quote one example. Did protectmarriage.com help to develop the contents of the 3 simulcast rallies referred to on this page? And Mr. Dusseault referenced the simulcast. Instruction not to answer. Everything we asked him to explain documents, they blocked our inquiry. So from what Ms. Moss is saying now, they would like to reserve the opportunity having blocked our inquiry, to have Mr. Schubert now, for the first time on the stand, give the explanation that precluded us from seeking from him in his deposition. It was really quite extraordinary, the way the deposition was handled. And I think it's really trying to have it both ways. Now that they are suggesting he would come up and explain these documents when they stopped him from doing it in his deposition.
Thank you very much
Thank you, Your
for
Honor.
your presentation.
Thank you, Your Honor.
I'm going to reserve on this for the moment. Let's see what documents come in, presented by the plaintiffs, and then to the extent it's necessary, we'll deal with whether Mr. Schubert testifies or not. We'll deal with that in due course. You have well presented the issue. I've read your papers, and I will further consider the issue when it becomes ripe.
Thank you, Your Honor.
All right.
The next preliminary issue I would like to have Mr. Boies address, it relates to Nathanson and Young deposition experts we played and the designations that proponents have now made.
Very well, Mr. Boies.
Thank you, Your Honor. Mr. Patterson and I have agreed, subject to the resolution of certain objections that we have as to what will be played. That is, we both designated and counter-designated to each other's designations. We've each designated and counter-designated to each other's designations, to each other's deposition requests.
Do you have additional designations?
These are additional from what we played. In other words, the court will recall that with respect to Professor Young and Nathanson, who were experts for the defendant, the plaintiff in their case played certain selections. And because we offered into evidence the deposition, they were entitled to come forward with additional designations. We've now agreed that what's present are responsive to our designations. We've made a few additional designations for contextual purposes, and we've all agreed that what we don't have agreed to is that we have certain objections to some of their designations on the grounds that their own designations demonstrate that the witness is not competent to testify about that subject.
The Doerr challenge.
The Doerr challenge, and it actually goes maybe even beyond Doerr in the
Doerr
sense that
plus.
Doerr plus, yes. And what we've done for the court's convenience, and you might begin with Professor Young. What we've done for the court's convenience is we've marked here in yellow the designations that they intend to play. And we've marked in red or pink the designations that they want to play that we object to. And the yellow ones are agreed to. The pink or the red ones are the ones we object to.
Well, hopefully and happily, most of these are yellow.
Most of them are yellow, yes, Your Honor, and we tried to keep our objections limited. But if I could just ask the court maybe to skim some of the initial yellow pages, which you'll see is that what they have done is that they've designated a whole series of questions and answers that demonstrate that Professor Young has very limited, in their view, expertise. They've established she's not an expert in psychiatry. She's not an expert in psychology. She's not an expert in sociology. She's not an expert in anthropology. She's not an expert in the field of child development. She's not an expert in political science. She's an expert in religion. But she is an expert in Hinduism. She has never done a study in the United States of whether there is bigotry or prejudice against gays or homosexuals. She doesn't. Question. You are familiar with Roman Catholicism, correct? Answer. It is not my area of specialization, subspecialization, which is Hinduism. She's never studied how many gays or lesbians are raising children or what the consequences of that are. She's not even familiar with what the views of homosexual activities are in the United States churches. She has not done studies as to what proportion of children today are being raised by people outside of marriage that she describes as the norm, Or what proportion of children are being raised by gay parents? Or what proportion of children are being raised by single gay individuals? Or she's not aware of the studies concerning whether permitting gay marriage will increase the number of children being raised by gay couples. And
I wonder, Mr. Boies, excuse me for interrupting.
Yes.
If perhaps a way to deal with this is for me to take these into chambers, review them, come back, and discuss them with you in the end. Is it Mr. Patterson who's dealing with this? Mr. Nielsen?
Your Honor, very briefly, the defendant interveners actually have a pending motion to compel against several no on 8 groups in response to some subpoenas we filed. We're happy to rest on our papers, but I did want to raise that because, of course, as we get into our case in chief, if the court were inclined to grant those, now would be the time when we do need those documents. And I just wanted to raise that that is pending, and we are not asking for argument, but we are asking for a ruling, I guess.
All right, very well. Mr. Dusseault, I gather, is going to be making the presentation. Is that correct?
Yes, Your Honor. Good morning, Your Honor. I thought it might be helpful to start what we've been referring to as the evidentiary presentation this morning with just explaining to you the goal that we're trying to accomplish and the discussions we had with opposing counsel about it. Our goal was to try to find as expeditious and efficient a way as possible to get a limited body of exhibits into evidence. Given that many of them were coming in during the trial, and the way that we've been sort of responding on the fly to some of the things coming in, and also dealing with objections and other issues. And I think I can put these documents into 3 general categories. The first was admissions by a party, and I think we've got pretty broad-based agreement there. The second is campaign issues and structure, which, as you've gotten a brief preview, that's the one where we have the most disagreement. And the third is a very limited group of documents that relates to witnesses who testified earlier that for whatever reason didn't come into evidence. So we're going to try and get them in at this point, and we've tried to reach agreement on those. These are documents that we feel there really shouldn't be. Number one, any legitimate dispute about their relevance to the case, about their authenticity, about the fact that they should be in evidence. And we also don't feel any need to ask witnesses questions about the documents. We just want the evidentiary record to reflect the documents and what they say. To start with the good news, we have been able to reach agreement on a relatively large group of those documents. I believe it's 46 documents, as to which counsel for defendant interveners have agreed that they have no objection. And I've given you that compiled, I've given that compiled list to Ms. Moss, but it was the result of our discussions beginning on Thursday. And I very much appreciate the courtesy that they showed in doing that. I'd like to hand this to the clerk and to the court. And Your Honor, I would like to ask that the documents on this agreed upon list be moved into evidence.
Ms. Moss?
This is the ones you handed me before?
Yes.
We have no objection, Your Honor.
Very well.
All right. Your Honor, as I mentioned, the first group of documents was admissions by parties, and fortunately we've had no disagreements there. There were a couple that we suggested that were not agreed upon, and we've withdrawn that. So I do have a witness binder that we've prepared that reflect those documents. To the extent that it's helpful to the court to have them, we can make it available. But all of these are in evidence now, and there's really no need for any further discussion of them.
Excuse me. These are what, Mr. Dusseault?
These are the documents that plaintiffs and defendant interveners have agreed are admitted and are now being admitted. And they are just copies of the party admissions that we just moved into evidence.
So,
okay, perhaps I can clarify. The list that we gave you includes some documents from each of the categories that I described. but all of the admissions are coming in by agreement. We just thought that the court might want to actually have copies of those documents available since we're putting them into evidence. But I'm not going to address them any further today. The next group of documents...
I assume at some point you're going to take me through these and tell me what you think these documents establish.
Yeah, we certainly can, Your Honor. And what we are assuming is that in closing or in any any post-trial briefing that you may ask for, we could certainly draw on certain aspects of it. If Your Honor would prefer, though, we can walk you through certain of the admissions as part of our case. We can certainly do that. The primary goal, Your Honor, was just to be able to have in evidence certain facts. Some of them are somewhat administrative, just to make sure that we're able to have authority for those as we go forward, if we do additional proposed findings or briefings or closing.
Look, I don't want to make your presentation overly long, but there are quite a few documents here, and exactly what am I supposed to derive from them is not particularly clear. If you expect the court to draw some fact or inference or admission from these, I think at some point you're going to have to, well, you need to tell me what it is you want me to get from these.
Fair enough, Your Honor. Absolutely. And we may be erring on the side of being expeditious since there was not a dispute, not trying to dwell on that. Perhaps what I could do, Your Honor, is to move on to the disputed subjects, and then we could confer about how to best put that in. The next category of documents, Your Honor, or the one where there's the greatest degree of disagreement, is documents relating to the campaign and to the structure of the campaign. And the first group of documents in this category is the one we talked about first thing this morning, these simulcasts. There are 3 videos of the simulcast that we would seek to move into evidence. And those are 503, 504, and 505.
503, 504, and 505.
That's right. Yes, Your Honor. And there are also corresponding transcripts that show what was said in those. And those are 1867, 1868, and 506. And 1867 and 1868 are certified court reporter transcripts of 503 and 504. And Exhibit 506 is a transcript that's available on iprotectmarriage.com website. It's put out there as a transcript of that particular simulcast. Your Honor, these simulcasts were conducted as part of the grassroots campaign before the election, and they were shown to Mr. Prentice during his deposition, and a clear foundation for moving them in was established. Mr. Prentice, I don't think there's any dispute as to these facts. Mr. Prentice acknowledged that the simulcasts were put on by the pastor's rapid response team, that they were held in one church and broadcast to a large group of churches throughout the state. Undisputed that ProtectMarriage.com provided the total funding for the simulcast, and also undisputed that the simulcasts were part of the grassroots campaign. So what you have here is activity reaching California voters before the election, paid for by the campaign. There is coordination with the campaign, so we think the foundation and the relevance as to these documents is really beyond dispute. If counsel would like to be heard on that issue at this point, we can do that. The other approach is there's a couple of other documents that I would like to move into evidence that talk about the simulcasts, and they may also resolve some questions the court may have. The first of those, could we have the exhibit binders? Are they already passed out? Okay. So we have exhibit binders presented to the court for the campaign materials. The first of these I would like to draw your attention to is Plaintiffs 2075.
Which binder is that?
This is the campaign materials binder that was just handed up, Your Honor.
In which of these binders?
On the spine, Your Honor, I believe it says exhibits to be admitted relating to campaign messaging.
2075?
Yes, Your Honor.
I see, here it is.
Okay. Now, I start with Exhibit 2075, Your Honor, because this is the one that we've already moved into evidence. There was no objection to this document becoming evidence. I would direct Your Honor's attention, and I think we can put this one, publish this one onto the screen as it's already in evidence. This document, Your Honor, is a blast email from Frank Schubert and Jeff Flint. And in the from line, it identifies them as campaign managers, protectmarriage.com, yes, on 8. So it's a blast email that they sent out in their official capacity running the campaign. And there's a passage 4 paragraphs down in the email that begins on, quote, on www.protectmarriageca.com. It says, you will also find information on 3 upcoming live video conference rallies. September 25 for pastors and church leaders, October 1 for young adults and parents, and October 19 for the entire congregation. So this document, which is in evidence, shows the campaign managers of protectmarriage.com alerting people to these upcoming rallies that had not yet occurred. The next document to which I would like to direct the court's attention, which is not yet in evidence, is Plaintiff's Exhibit 421. Do you have that in front of you, Your Honor?
Very well.
Okay. Your Honor, Exhibit 421 is one of the ones that I referred to this morning that we got from the website. It wasn't produced. I did, Your Honor, in abundance of caution, check that website this morning over breakfast in my hotel room to make sure that it's still there. So it's publicly available today. And it is from a website called protectmarriagesimulcast.com. But what I would note, at the very top of the text here, it says, protectmarriage.com presents.
Where do you see that? Oh, I see it, right.
Okay. Protectmarriage.com presents, which seems to be a rather unequivocal endorsement, contrary to some of what we're hearing from opposing counsel, that protectmarriage.com was directly behind the presentation of these rallies. I would also note, Your Honor, that what this website does is offer for sale DVDs of each of the rallies at a price of $5 a piece. This is how we obtained them. So these DVDs are not confidential. They're in public. They're available for $5. We got them in that manner. And the very website from which we got them says it's presented by protectmarriage.com.
Well, there is a reference to, is there not, to, for more information about Proposition 8, visit www.protectmarriage.com.
Yeah, there is, Your Honor. So, Your Honor, I would move Exhibit 421 into evidence.
Ms. Moss.
Your Honor, this Exhibit 421, it's not a website of protectmarriage.com. It's a website created and maintained by a separate organization or individual. I don't know actually who maintains the website. Protectmarriage.com had no control over what was put on this website, and Mr. Prentice, in his deposition, indicated that he had never seen this and was unaware that these simulcasts were for sale. So the fact that they pulled something off the internet that, you know, that suggests that these simulcasts were for sale and attempting to say that, therefore, somehow protectmarriage.com is responsible for this, they haven't laid that foundation. I mean, no one has testified that protectmarriage.com maintained this website, and indeed the only testimony on this from Mr. Prentice's deposition was that he was not aware of it. The campaign does not dispute that these simulcasts were paid for with money that was raised by protectmarriage.com, but there is no evidence that they had control over the content of these simulcasts or what was said in these simulcasts. And Mr. Prentice was not shown these simulcasts at his deposition. I mean, we don't know what is in these, what's in these simulcasts, which are, I think, you know, each over an hour long, maybe an hour and a half long. You know, what in them specifically the plaintiffs are contending are of relevance. I believe that Mr. Prentice testified that he did not attend these simulcasts. I'm not sure, and my memory could be wrong on this, but I don't know that anybody from protectmarriage.com was at these simulcasts. So without some further, I guess, direction or tender from the plaintiffs as to what is in these 3, hour and a half long videos they contend is relevant, we're sort of at a loss for how to respond to them. I mean, we won't dispute, and we don't dispute, that the money was paid for, but this is not a protectmarriage.com website. I mean, they did not offer these simulcasts for sale, and we do not produce them, and we don't necessarily object to the authenticity. I mean, we agree you can go to the website, and the website is as it is, but these were not, I mean, these are not from the files of protectmarriage.com, and we don't believe that they have laid a foundation.
Mr. Dusseault, what's the evidence here?
Well, Your Honor, again, I think Ms. Moss just conceded that the simulcasts are paid for by the campaign. So I think that the statement that it's presented by protectmarriage.com is established as truth by that admission. But this is a document, Your Honor, that we've alerted them to on our exhibit list and told them Thursday was part of what we were going to move in. And as I said, the website this morning still says protectmarriage.com presents. So I think it's a bit odd to hear that they are somehow suggesting that that's a misrepresentation when it's on this website. I do have another document, though, that might shed some light on this. If Your Honor would like to consider that one before ruling on the admissibility of this one.
Very well.
Okay, if you could look at Exhibit 2656, please. Do you have that one in front of you, Your Honor?
Yes.
Okay. Your Honor, Exhibit 2656 is a document produced by the defendant interveners. And it was produced during the trial, as I understand, so we didn't have it at the time of deposition. It's an email chain between Jim Garlow, who was one of the driving forces behind the simulcast, and he sends an email to Mr. Flint. But about halfway down the page, Your Honor, there is an exchange between Mr. Pugno and Mr. Garlow about a card relating to these events. And you see there's 3 points that Mr. Pugno makes. The first is about a statement that says, quote, CNN is broadcasting these events at no charge, unquote. He says, quote, if we, presumably protectmarriage.com, are paying CNN, we can't say CNN is broadcasting at no charge. We can say CNN is broadcasting the simulcast at no charge to the participants. The second point is the one, Your Honor, I think that goes directly to Ms. Moss' objection. This is Mr. Pugno saying, all of the CWA references need to be taken off. CWA presents should read protectmarriage.com presents.
What's CWA?
Concerned Women for America. So this is a postcard about the events where Mr. Pugno is specifically directing that the simulcast should be described as presented by protectmarriage.com. And then the third point is also relevant, I think, to the extent defendant interveners are trying to distance themselves from this event. In that it says, quote, the mass mailing must also be identified as coming from the campaign's address, not CNN's. The campaign being protectmarriage.com. So, Your Honor, I would move this Exhibit 2656 into evidence. And I believe it's further evidence that Exhibit 421 should come in.
Is there an objection to admitting 2656?
I guess no, there's no objection to admitting 2656.
Very well, 2656 will be admitted.
Your Honor. Your Honor, I would simply point out the advice that Mr. Pugno is giving here in there is referring to the card in that exhibit. We have stated that, and it was advice that was being given because since money was going to pay for these simulcasts under the disclosure laws that had to be present, that disclaimer had to be present, but it does not follow that ProtectMarriage.com knew or authorized that these simulcast events be published on the website or that they be sold on the website. Again, the testimony from Mr. Prentice was he was not aware of that, and none of that money came to ProtectMarriage.com. And it still doesn't address the further point, which is, you know, while they may have offered money to pay for this, to the extent that they're trying to draw the inference that somehow this means that ProtectMarriage.com controlled the content of those simulcasts, that has not been established. And we don't know what in these simulcasts they're contending is relevant or what specific significance there is about these simulcasts.
Well, I gather there's no question that ProtectMarriage.com didn't pay for these simulcasts.
That is correct, Your Honor.
And those are the simulcasts which are referred to in Exhibit 421.
Yes, Your Honor.
Very well, I think that's sufficient basis upon which to admit 421, and it is admitted.
Thank you, Your Honor. And 2656 has also been admitted.
Yes, 2656 is in.
And one final document, Your Honor, I would like to admit, before asking the court to admit the videos and transcripts, is 2655 also in your binder? Your Honor, Exhibit 2655 is a document produced by the defendant interveners to us during trial, pursuant to Magistrate Judge Spiro's order. And it's an email from Tracy Berger at Skyline Church to Ron Prentice, who was the chair of ProtectMarriage.com. And it attaches a number of materials. The first page that follows the email is a webinar conference called Agenda. First 2 pages. And then 3 pages into the attachment, Your Honor, there's a page, Defendants 24257. It says, Satellite Simulcast, September 25th, Thursday, 7 o'clock p.m. And to the extent that there's any question about coordination of content at these simulcasts with the campaign, it's worth noting that this is a 4-page agenda of the content of one of the simulcasts that's being sent to Mr. Prentice before it takes place. So we would seek to move Exhibit 2655 into evidence.
Ms. Moss?
Your Honor, this is an email from someone outside ProtectMarriage.com and its executive committee to Mr. Prentice. This is, as far as I know, no documents that they are offering that show that there was any response to this email, that Mr. Prentice ever reviewed this email or even read this email. So I don't think that standing alone, it establishes anything other than the fact that Mr. Prentice received this email.
Well, but that goes to the weight of the evidence, doesn't it, rather than its admissibility?
Well, and Your Honor, if I could add, we're not offering it for the truth of the agenda. We're offering it to disprove some suggestion that ProtectMarriage.com wasn't kept apprised of what's going to happen at these simulcasts.
Very well, 2655 will be admitted.
Thank you, Your Honor. So, Your Honor, I think that brings us back to the simulcasts themselves.
Let me go back just to be sure from my notes. Do I understand there is no objection to 505, 504, 505, 1867, 1868, and 506? Is that correct?
No, Your Honor. No, Your Honor. Our objection again would be we don't believe that they have shown or offered what specific significance or relevance there are to these.
All right, and it is to that you are now turning.
Yes, Your Honor.
All right.
And Your Honor, I think the relevance is quite clear from what we've established, that this is paid for by ProtectMarriage.com, represented at Mr. Puna's request as presented by ProtectMarriage.com. It is messages that were communicated to California voters before the election. I think the relevance of that is really self-evident. We would like for the entire 3 simulcasts to be part of the record of this case. But what we have done is we have about 6 minutes of clips that we would like to present to the court. And my hope would be that we could admit the simulcasts as relevant admissible evidence and then present to you, as the finder of the facts, portions of that that represent messages that were being presented to California voters at the expense of the campaign before the election, as clearly relevant to the issues before the court.
All right, so it's the excerpts that you're asking the court to rely upon in making its findings?
Yes.
Okay.
So, with Your Honor's permission, if we could play those excerpts?
You may.
Thank you, Your Honor.
This is 503.
Well, these actually are excerpts. They are excerpts from 2 of the 3 simulcasts, Your Honor.
Which ones?
Let me make sure I have the dates right. Get some help from my team to make sure I don't misstate that. Okay, the excerpts that we played were from PX 504 and PX 505.
Okay.
Okay. We would, Your Honor, ask to be able to move in the actual DVDs that we obtained from the website, in total 503, 504, and 505, and the transcripts. And what we could do, Your Honor, we could, and I think we've done this with some of the other excerpts that have been played, submit later today a document showing where in the transcripts the excerpts came from.
That would be helpful, Ms. Moss.
Well,
Sorry.
well, Your Honor, we maintain our objection. I would request that if they are going to come in, that we be given copies of these excerpts so that we can determine under the rule of completeness if there is additional portions of those simulcasts that we may need to come in to be played and highlighted for Your Honor, to put these excerpts in context and to provide full breadth.
Very well. With that understanding, 504 and 505 are admitted.
Thank you.
Your Honor, what we would do, we would submit the list of the excerpts as an exhibit, 504A, just so that the record is clear.
All right.
And Your Honor, for clarification, we would ask that exhibit 503 also be submitted into evidence and the transcripts. Although we didn't draw a video from 503, we think it's analogous to any other document that may be introduced into evidence, and when a particular page is called to the court's attention.
But it was another one of those simulcasts that's referred to in the exhibits that have been admitted.
Correct.
421, 2656, 2655. Very well. 503 will be admitted on that basis, and we...
And just so the record is clear, the exhibit numbers of the transcripts are 1867, 1868, and 506. We would ask that that be admitted as well.
Very well.
All right, Your Honor, then, with that taken care of, the next document as to which we have a disagreement relates to these simulcasts, and it's in your binder, Exhibit 2773. Your Honor, Exhibit 2773 is an email exchange between Pastor Garlow and Ron Prentice of ProtectMarriage.com. The first portion of the exhibit is an email from Garlow to Prentice, but the second portion of the exhibit is written by Mr. Prentice, who runs ProtectMarriage.com, and sent to Mr. Garlow and others, CCing Schubert and Flint. So we would seek to move Exhibit 2773 into evidence.
Your Honor, objection. Again, it would be that we just think that there needs to be some tender about what specifically they believe this document is showing. I mean, what relevance it has, what sort of inferences we should be deriving from it, so that we know whether or not we need to respond with evidence, should we have any to respond with.
Your Honor, I'd be happy to do that. I had hoped to do that after moving it into evidence, so that I could publish it on the screen and make clear what I'm talking about. So if we could move it into evidence, I would be happy to highlight the portion of that we wish to draw the court's attention to.
One other point I would like to make, Your Honor, is this is a post-election document.
Yes, I noticed that.
Your Honor, if I may, I think I can explain the relevance. It is a post-election document, and it's a post-election document in which the head of ProtectMarriage.com is trying very hard to make sure that these simulcasts don't get out to the public, simulcasts that happened before. So while the email itself took place after the election, it's talking about pre-campaign messages, pre-election messages in the campaign, and a concern if those were to reach a broader audience.
And your point is that that goes to the control of the simulcast.
Yes, it does, Your Honor. I think it also goes to the state of mind of the defendant interveners about what's contained in those simulcasts. If it would help, Your Honor, I can read to you the portion I'm referring to. I just thought it might be easiest to just
I assume that you are referring to Mr. Prentice's message of the 16th of November?
Yes, I am, Your Honor. And this is about a Dr. Phil show and what's going to happen on a Dr. Phil show. And what Mr. Prentice says is, quote, "We must control the message from the simulcast. Jim, I don't see how using any portion of it will not permit the show to direct the message to the religious bias." Now, we think it's directly relevant, Your Honor, that ProtectMarriage.com, after the election, was trying to make sure that a national audience, like an audience of the Dr. Phil show, didn't learn of this religious bias. And that's Mr. Prentice's words for it. It is not mine.
Very well, 2773 will be admitted.
All right, Your Honor, the next two documents that we seek to move in are videos. They are two-part videos of rallies where Mr. Prentice spoke. Again, we don't really see how there could be any dispute over this. They are videos showing Mr. Prentice talking, and they are pre-election videos. They are admissions that are admissible for that purpose. And we would seek to move Exhibit 390 and 391, the videos, into evidence, and then to play about 2.5 minutes of those into the record before Your Honor, once it's been admitted.
390 and 391?
Yes, Your Honor. Both videos.
Ms. Moss?
Yes, if I'm correct, these are videos that were shown in their entirety to Mr. Prentice at his deposition, which he did lay a foundation that, you know, it was him speaking, and he recalled it, and we don't have an objection to
Very
these
well,
videos.
390 and 391 are admitted.
Okay, then, Your Honor, I would now ask permission to show the excerpts from Exhibits 390 and 391. Thank you, Your Honor. What we'll do, as with the prior exhibit, we'll present an Exhibit 390A that will show the excerpts that we played from that rally.
Very well.
All right, Your Honor, the next document to which I would like to draw Your Honor's attention is PX21. Your Honor, PX21 is a flyer produced and distributed by something called the California Family Council Foundation. You may recall the California Family Council was one of the entities that Mr. Tam said was part of the Broad Coalition. Mr. Prentice is also the CEO of the California Family Council. I don't believe that there's any dispute that this is a flyer that was distributed in an effort to persuade voters as to Proposition 8, that it was before the election and put out by this organization that shares the same leader as ProtectMarriage.com. I don't believe there's any dispute as to its authenticity because it came from the flyer. And I believe, it came from their files. And I believe during the trial, Your Honor. So this is something that we believe should properly be considered as part of the body of information that was before the voters. And again, I think any effort to distance the campaign from knowledge or control is undermined by the fact that Mr. Prentice is CEO of this organization as well.
Ms. Moss.
Well, as the face of the document makes clear, it is not a protect marriage document. I don't know that there has been any testimony or evidence offered that this was in fact distributed. It came from the files of protectmarriage.com. I don't know that there's anything in evidence regarding whether this is a draft. I think that there was a dispute at the deposition about the exact date of this document. Mr. Prentice's testimony, I believe as well, if I'm recalling correctly, was that some of the organization listed on the document were not necessarily involved in the Prop 8 campaign. So there was a question as to, I mean, it raised a question as to whether this was a draft, whether it had been distributed. I'm not clear on those points. And I think without the foundation being laid, without that foundation being laid, that it should not come in as something that was distributed. And if it was, well, then I think there should be some evidence that should come in with it as to who it was distributed to and who it was placed in front of. I mean, did it go to the voters in California or to some other group of individuals? I mean, Mr. Prentice is the head of the California Family Council, but I don't believe he drafted this document. It's just something that happened to be in his files and therefore got produced.
Again, this appears to go more to the weight to be attached to the document than its admissibility. Therefore, without resolving how much weight to afford the document, it will be admitted. PX 21 is admitted.
Thank you, Your Honor. All right, and with it admitted, I would seek to publish it on the screen to direct the court's attention to two portions. On the second page of the exhibit, in the left-hand column, there is a section called background, or issue background. And Chris, if you would highlight the text that begins, the goal. The text to which I would like to draw the court's attention reads as follows, quote, "The goal of the homosexual community is not marriage. In fact, the countries where homosexual marriage is legal, no more than 3% of homosexuals are married. The ultimate goal is the annihilation of marriage and full legal acceptance of homosexuality." Your Honor, I would also like to direct the court's attention under legislative history to this section, which refers to 1999 and describes the onset of domestic partnership as the California legislature beginning an incremental attack on marriage. Your Honor, the next two exhibits that I would like to address are PX 480, which is a video, and PX 2681, which is an article by the group that produced the video. Now, as far as I understand, there's no dispute as to the authenticity of the video. The video was put out by the American Family Association, which donated, I believe, $500,000 to the campaign. This video includes clips of Mr. Prentice, which we believe would belie any claim of a lack of involvement or knowledge on the part of the campaign. And I don't believe there's any dispute that it was made available to voters before Election Day. So we would seek first to move into evidence Exhibit 480, and then once admitted, have permission to show excerpts as we've done with the other videos.
Ms. Moss?
With respect to the video itself, Mr. Prentice was shown this at his deposition, and he did recognize himself in the video. I don't know that there was any testimony or any evidence offered about where when or where this video was made available. So to that extent, I don't think that it's been established that this was made available in California to voters before the election. I just don't know. I don't know, and I don't know that they have offered that evidence. And until they do, we would object that it's not relevant. You know, it may have been filmed at the time, but I don't know if it was made available. And likewise, the website that talks about the video, it's a website. It's not a protect marriage document. And you know when it was, whether it was available at the time, I don't believe the printout shows. There has been no testimony.
You're talking now about 2681?
Yes, I'm sorry, Your Honor, 2681. I don't know that there has been any testimony that was available on the web during the election. It's certainly something that you can go to the website and pull down now, but it does not mean that it was there, that there has been evidence showing that it was there and available during the election.